All right, here we go. Today we're going to talk about the super exciting topic of choosing the correct business entity for your business in the state of Florida. A few really important notes before we get into anything. This is not legal advice. This is a broad overview of some of the topics that hinge on the decisions we're going to discuss today. The best decisions for you and your business are often very fact specific. So it's really important to consult an attorney about a decision like this who knows your facts and circumstances. We're recording this today. It is February 4th, 2021. Obviously, we just put in a new presidential administration. We just changed control of the Senate. There's a lot that's changing on the federal side and on the state side, but particularly with tax. So please keep in mind, this advice will not age particularly well when it comes to tax and maybe some other areas as well. About us, my name is Max Levine. I run the law offices of Max Levine. I'm an attorney. I focus exclusively on advising growing businesses, small businesses and startups, whether it's creators or tech startups in South Florida. We have offices in Fort Lauderdale at General Provision downtown. I have actual business experience. So I have built, grown, and now sold a normal non-law business to a private equity group. And so I know what it feels like to stand in your shoes and to get advice from an attorney and to pay for it. So I try to keep that in mind when I'm advising my clients. We are your general outside counsel for your business. So I deal with issues like tax, contracts, employment law, intellectual property, advertising. Basic goal is to become a part of your decision-making process, to integrate legal knowledge and make sure that as you're accelerating your business, you're just not accelerating headfirst into a crash with the law. So what's the point of this talk? The reality is every business person needs to know about the decisions we're going to talk about today, whether to operate as a business entity, which one to operate as, and how to be taxed for federal income tax purposes. I'm going to give you a basic understanding of your choices and their effects on your business. And I'm going to encourage most business owners to operate under business entities. I also want to just get you to raise your hand. Some of this stuff may not seem particularly important to your circumstances. Some of this stuff may not be particularly important to your circumstances, but sometimes you're going to go, oh, that's me. Okay. And when that's you, it's really important to focus on that and to probably discuss that with an attorney. This is a very frustrating talk for me to give. As an attorney, I like to deliver actionable answers. I don't like to give answers that go, well, it depends, blah, 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 blah. No. Unfortunately, in this case, the topic is so broad and it impacts so much of what you do as a business person that my answers here, trying to give this talk in, not 7 hours, are going to be, it depends. And I imagine myself in the audience, snarky lawyer, going, you forgot about that, or why didn't you mention that exception? Yeah, I'm trying to do this in less than 7 hours. So again, broad overview. What are we going to talk about? We're going to talk about some of your choices, what your choices are and why this decision matters. We're going to talk about some impact of those choices. So these are some broad topics about doing business. The impact on liability, the cost of formation and maintaining business entities, how different business entities affect your management and control of your business, whether, how they change your flexibility and ownership, how they impact raising money from various sources like venture capital, friends and family, banks, things like that, how they impact how you compensate your employees. And then we're going to get into tax, which is kind of the tail that wags the dog. The federal government is effectively your partner in any business you start in the United States of America. The question is, how much of your money do they take while you do business? And then we're going to just discuss two examples of somewhat straightforward situations where the answers are very often a little bit more clear as to how you should do business, under what business entity, and how you should be taxed. So let's get into it. So what are your choices? Surprise, surprise, it's already complicated, okay? It's important to note you're going to make two decisions. You're not just choosing to be a corporation or to be an LLC. You're choosing what state entity to do business under. So there's your corporation and your LLC. And you're also choosing how that entity is going to be taxed at the federal income tax level. We are not going to talk about tax for now. We are going to talk about it, but we're not going to talk about it yet. We're first going to focus on how your business is going to be formed, what business entity you're going to form at the level of the state of Florida. Okay. So for your state entity, you have a few choices. Let's say you don't do anything. You do not form a business entity and you have one owner. Congratulations, you are a sole proprietorship. If you do not form an entity and you have multiple owners, congratulations, you are a partnership. Now, let's say you do the paperwork, you file something with the Florida Secretary of State, Division of Corporations, and you have some choices. You can be a corporation, you can be a limited liability company, an LLC, or you can be a few other entities that we'll discuss. I'm just calling those the other section for now. So what if you get it wrong? The reality is that you'll have to convert to whatever the right entity may be when it matters. And conversion is ugly. Conversion, once a business is up and running, can be really expensive. It's easy to get wrong, and it can have major, major tax consequences. One example is, let's just say you start as a Florida corporation, and then you decide you need to be a Florida LLC. All classes of shareholders in your Florida corporation must vote in favor of that conversion. What that means is that some investor in your company who might not be so happy with how things are going can now hold everyone else up in some situations from doing something that's really important for your company. And conversions are confusing. So this somewhat smug but confused looking guy is Eduardo Saverin. He went to sleep owning 23%, I think maybe 24% of a Florida LLC. He woke up owning just 10% of a Delaware corporation. And of course, what was that company? What was that business? That business was Facebook. So he's still not looking too unhappy, but he did kind of get screwed. What are your choices? Okay, so again, we're going back to, let's say you don't file any business entity, you just do nothing, okay? So if you do nothing and you do business, you just don't file any paperwork, you're now a sole proprietorship if you're an individual, and you're a general partnership if you have more than one owner, okay? So if you have more than one owner, you are kind of a de facto partnership. And if you don't have any agreement between the multiple owners, any partnership agreement, the Florida statutes have some laws about you, about how partnership decisions can be made and who can represent the partnership to other parties. And those rules kind of stink. One example is all partners are deemed agents of the partnership. So let's say I am partners with Tom. I go to Bank A and I pledge all of the assets of the partnership for a loan from Bank A. Simultaneously, Tom does the same exact thing with all of our assets to Bank B. We've now got 2 loans outstanding and a huge mess, okay? You want to have an operating agreement. You do not want to have situations like that. And there are lots of rules in the Florida default partnership rules that don't make much sense for most partnerships. So if you are a partnership, it is kind of critical to have a partnership agreement. Let's say you do decide that you want a business entity. We're just going to talk in broad strokes about what those things are. So they're created by filing paperwork with the Department of State. Again, I'm talking about some really, really basic issues here. I apologize if this is boring to some of you, but I just don't want to leave the important stuff out. Okay, so there you file paperwork with the Department of State, excuse me. Business entities are an independent legal person. It means they have the right to act as a person under the law for lots of purposes, not all purposes, but for lots of purposes. They have indefinite existence, the ones we're talking about. So there's no wind-up date. If an owner dies, the entity continues to exist. And they're characterized by centralized management through agents, okay? So you have individual human beings who are capable of managing the business entity. Sometimes it's even other business entities. And then you have agents, business entities again, or actual people who are able to act on behalf of a business entity, okay? The owners of those entities, whether they're called shareholders or interest holders, they have the right to residual earnings and assets, meaning everybody who's owed money gets paid first, and then the owners take the profits, take what's left, take whatever assets are left after all the creditors are paid back. And of course, they are characterized, business entities are characterized by limited liability for participants. So that means limited liability for owners, limited liabilities for directors, if there are directors, and limited liabilities for officers, employees, and the like. We're going to talk a lot more about limited liability, but just giving you broad strokes for now. So what are your choices? Drilling down to the different types of entities, you have a corporation. So a corporation, the governing law is going to be Florida statutes. If it's a Florida corporation, it's going to be Delaware statutes. If it's a Delaware corporation, there's a specific reason we're mentioning Delaware corporations. We'll get to that later, but basically just know corporations are creatures of statute, okay? The basic structure of a corporation is owners are shareholders. They own stock, okay? You have a board of directors that is mentioned, that is named in different corporate documents. They have broad operational oversight. They don't deal with the day-to-day, but they appoint and oversee the officers of the corporations, The officers have day-to-day control over the corporation, and they report periodically to the board of directors. And of course, if it's just you, those roles can overlap. You can be the president, secretary, sole shareholder, CEO, all of those roles if you are the only person involved in the corporation. It's not just for Fortune 500 companies. Your other main choice, if you are going to create a business entity and do business under it, is the limited liability company, or the LLC. Again, the governing law here is statutes, but there's a difference. LLCs are kind of marked by more flexibility in how they work than are corporations. Okay, so you draft an operating agreement for that LLC. And generally, the operating agreement is kind of your guide of the inner workings of that LLC. Of course, there's limitations, but it's got more flexibility built into it than a corporation does. Basic structure of an LLC, the owners are called members. They have LLC interests or units. They're just owners. Similar words, there are differences between owning stock and owning LLC interests. And again, there's no such thing really as stock in an LLC. That's only for a corporation. LLCs do not need to have boards of directors. Okay, that's one basic difference between a corporation and an LLC. The authority to run an LLC is granted either to members or to managers, okay? And it's important to know here, manager doesn't mean she's in charge of anyone in particular. It just is the person named in the articles of organization at the Department of State level. So then there's the other business entities that you can run as, or the other legal entities that you can run as. You have some things for specific purposes like nonprofits and professional entities. So my law firm is run as a PA, a professional association. What that means is that it's basically like a corporation, except lawyers are required to operate as a PA or a PLLC because it passes through professional liability. I cannot be protected from malpractice by my entity. That liability passes through. I have to operate as a PA, PLLC, or the like. There are also other business entities which are pretty interesting. So there's for-profit social purpose and benefit corporations. If you want social or environmental responsibility kind of baked in, if you want that to be part of the DNA of your company, that's something worth considering. It's a relatively new area of law in Florida and really nationally. There are some quirks with it, but it is worth talking about if that's something that's really, really important to who you are as a company. Okay, so now we're going to look at these choices. We've briefly described what they are. Now we're going to look at them through different lenses, okay? Different lenses about how you're going to operate your business and how they're going to affect you as an owner of this business. So we're going to talk about liability first, okay? Really, really basic. What does liability mean? It means you have to pay when the business owes something, okay? If you have no entity and you are a single owner, you are a sole proprietor, you are liable for the business's debts, whether you sign some kind of contract or you owe a vendor money or you, God forbid, hit somebody with a car, you are liable for whatever money is owed by that business, so to speak, because there really is no thing besides you. It's just you doing business. If you have multiple owners, partners are liable for partnership debts if the partnership can't pay them. So generally, creditors of the partnership are going to go after the partnership first, and then they're going to go after partners in their individual capacity. With business entities, again, your corporation, your limited liability company, it's a little bit different, okay? So there is limited owner, director, officer liability for entity debts and judgments. Basically, owners are going to be limited to basically their investment in the company or in the corporation in terms of how much they can be sued or how much they can lose when the entity owes money. And just to be really clear, what does limited liability mean? I know, I'm sure some of you are familiar with this, but it's really important for me not to omit this. Limited liability means sometimes not paying valid debts. It means something has happened in the business where they clearly do owe money. It could be just a business debt. It could be a tort debt. Somebody's gotten hurt, the company gets sued. A jury or whatever establishes that a certain amount of money is owed. Limited liability means you can only come after the company for so much. Even if that amount is correct, you are limited to coming after the company for so much. Like I said, for owners, the business assets are at risk to those debts. Personal assets are not, and vice versa. If an owner owes some money, his or her personal assets are at risk if he owes that money, he or she owns that money in his or her personal capacity, but the business assets are generally not at risk. We're going to talk about that in a little more detail. There is in Florida a very important difference between corporations and LLCs in this regard. So let's say you have a multi-member LLC, it's owned by multiple people. And let's say I'm one of those owners and I owe money to everybody in town, okay? So my creditor can't take control of my ownership interest in an LLC, okay? It's actually important. They can get what's called a charging order from a court, which basically means whenever the LLC is about to pay me 10 grand because that's what the owners get, the charging order directs the LLC to make that payment to my creditors instead. But charging orders all they get. They don't get to control my ownership interest in the LLC, okay? With a corporation, let's say we did that business through a corporation and I own shares, my creditors can get control of those shares, which means they can get control of votes. So shareholders vote to control the corporation. They tell the board of directors to do what to do in broad strokes. They elect the board of directors. And that means that my creditors can now get some operational control of the business. Where does this matter? Okay, it matters when you are co-founders in your company with someone who has major personal risks. So situations I've seen are somebody with a history of substance abuse or a really, really messy personal life where there might be a very ugly divorce going on. A piece of your company could end up contested and potentially in the hands of someone that person had a relationship with. It also is relevant, again, a situation where your co-founders, your co-owners' financial life at the individual level is just a mess and they just owe a lot of money. You could get dragged into court on that. There are other ways to deal with this, particularly in the corporation situation. You can have restrictions on transferability, complicated area. We're not going to get into that today, but it's important to know this basic difference between an LLC and a corporation in Florida. Again, though, this only applies to a multi-member LLC. Okay, there's a little bit different, a little bit more liability if you have a single member LLC. Big question. Doesn't insurance protect me from liability? Why do I need to have a business entity? And then similarly, doesn't a business entity without insurance protect me from liability? Why do I need insurance? So the answer is both of them do protect you, but there are limits on both, okay? Insurance will have dollar figure limits and carve-outs. Sometimes those carve-outs are going to be really, really important to your business. They may not protect you from negligence. They may not protect you in certain situations that really, really are risks in your business. Similarly, a business entity without insurance, yeah, it may protect your individual assets, but it's not going to protect the business itself. All of that is at risk for business debts, it's at risk to business creditors. So if that's an important part of your livelihood, you're going to want to insure that. There are also sometimes when business entities don't limit liability. So like I mentioned, a PA or a PLLC for professionals, engineers, architects, doctors, lawyers, that liability for professional malpractice flows through the entity and hits me individually. Even with a normal business entity, there are situations where some form of liability is not going to be stopped at the entity level. There's something lawyers like to talk about a lot. It happens extremely rarely. It's called piercing the corporate veil. It means that you've got a corporation that was formed for improper conduct. It was run improperly as an alter ego of one or a few shareholders. Usually that means some controlling shareholders are treating the corporation as their personal piggy bank, and they're trying to do some fraud with this entity. In those cases, a court will pierce the corporate veil and go to the owner's assets when there's liability created by that company. This is not something we're talking about in a normal business situation. I don't know why we're talking about piercing. I don't know why we're talking about veils. That seems very, very Anne Rice to me, which is cool, but I don't know how she made it into corporate law. Reality is lawyers like talking about this more than it actually happens. If you're doing business for a real reason, if you're respecting basically the formalities of that entity, piercing the corporate veil is not going to matter too much to you. However, there are very, very real liabilities which are not protected by a business entity. One example of those is employment taxes. If you don't pay employment taxes that are due at the entity level, right? The employer's portion of the employment taxes, if you're not remitting things, the responsible person may be individually liable for those employment taxes. Now, if it happens by accident, it's a little bit of a different situation, but if that's what you're doing on purpose, yeah, you may be on the hook individually. Another common situation where you may be on the hook individually for a business liability within a business entity is when you make a personal guarantee, which is super, super common in all kinds of industries. Sometimes the banks want to loan you money, but they'll only do it if you put up your personal assets. If you give a personal guarantee, the business entity is not going to protect you there. Also, direct tort liability. So if you are making a delivery and you're working for your business that is formed as an LLC and you run over someone with your car, you are going to be sued in your personal capacity as well as potentially in the business capacity. Okay, so that's the broad overview of liability. Let's talk now about cost. Okay, so entities do cost a couple extra bucks to form. It can be a few $100s. In different states, it can be way more expensive. And they do sometimes require a little bit more legal help. Again, you're going to want that operating agreement if you're an LLC. You're going to have to, do a little bit of paperwork if you're a corporation. You may need a little bit more tax help as well. You may not. We're going to talk about that later. But the reality is doing business is not free. Even if you don't form a business entity, you've still got local business taxes and licenses. You're going to form a brand unless it's just you. You're going to want to file a fictitious name filing, and you're still going to want to go get insurance to protect yourself from liability from the business activities. So people have this notion that like forming an LLC or corporation is their only filing expense. And it's just not a reality. There are costs of doing business. And that means that this is it's not a drop in the bucket, but it's not a yes, no. You're going to end up paying some money to professionals. You're still going to end up getting insurance. You're still probably going to need a fictitious name filing. Well, that's a little bit cheaper. So the reality is, because there are some of these costs anyway, it's a few $100 more per year. The additional cost seems sensible for forming a business liability as opposed to kind of going naked without having one in place for your business. Those additional costs do seem sensible on a liability basis alone. The reality is businesses have problems, and judgments in the state of Florida last for 20 years. So if you have a problem and you don't want that to last for 20 years, meaning those creditors are coming after you potentially for 20 years, you probably want to form a business entity and do business under it, okay? So for the rest of this talk, we're going to focus on doing business as a business entity, and we're going to focus on the two which relate to most situations, which are the corporation and the LLC, and we're going to compare them. So management and control. The way you manage and control a corporation is slightly different than the way you manage an LLC. So corporations are, again, marked by a little bit more formality, particularly for bigger events in the life cycle of a business that may require shareholder votes, a little bit more corporate kabuki, a little bit more paperwork flying around. One example is that corporations generally must have board meetings. Shareholders must vote on major issues. You got to have things like minutes, and there's a little bit more paperwork, again, that you have to keep track of for all of these things. Now, nobody likes formality the first time they hear it, but the reality is you got to step back. Formality has its advantages. It's an opportunity to make sure that everybody involved in the company is on the same page with regard to major events. It's an opportunity to take stock of where your business is and get advice from everybody in the room, get everybody's opinion. You can have a board of directors who are actually more experienced business people who might be honored by you asking them to serve on your board. And you may be able to get them to really care about your business through that position. Now, formality, of course, also has its disadvantages. It means that you need to be working with someone who knows what paperwork needs to be completed and what needs to be filed and by whom. So it generally means you do need a little bit more involvement of an attorney than you might if you have an LLC. There are ways to limit the paperwork required if you are a corporation, but sometimes even that requires a little bit of paperwork. LLCs, in contrast, are marked by a little bit more flexibility, okay? So when you form an LLC, basically you got to send a couple pages to the state of Florida, and that's that. You can kind of operate without anything else. However, that is not the best thing that that's not the best move at all. I would never advise that. Smart owners think through the life cycle of their businesses and have operating agreements that reflect that. Particularly, of course, if you have multiple owners of the business, you need to have rules of the road for how you are going to manage that business. What's going to happen when there are disagreements? What's going to happen when someone wants to leave? What's going to happen when someone stops working on the company at all? That your operating agreement provides for, a good operating agreement provides for all kinds of scenarios that are informed by very experienced business people and attorneys. And it gives you a roadmap for your business and allows you to get things done that could grind to a halt without an operating agreement in place. So an LLC, your operating agreement is really where it's at. That's your Bible, that's your God. Significant difference between LLCs and corporations: fiduciary duties. You may have heard about these things in different contexts. Fiduciary duties basically arise when one person is charged with taking care of another person, particularly their money. So there's a duty of care and a duty of loyalty. They generally require boards, officers, controlling owners to make informed, non-self-dealing decisions in the best interests of others, whether those are minority shareholders or just shareholders generally. They have to make decisions that are not self-dealing. They have to make informed decisions, and they have to act in the best interests of those others. Violations of fiduciary duties can and do cause major lawsuits, particularly between shareholders or minority shareholders and majority shareholders. There's a lot of situations where fiduciary duties are the basis, a violation of fiduciary duties are the basis of a lawsuit. And that difference, the difference between an LLC and a corporation, broadly speaking, LLCs can waive the fiduciary duties of, I think, let's see, board members, of majority interest owners, and I think officers as well. Got to double check on that. But corporations cannot. Fiduciary duties kind of baked into a corporation. It's not necessarily a bad thing. There's an inherent standard that your board of directors and officers and majority shareholders are held to, but it can be the cause of lawsuits. Another significant difference between an LLC and a corporation is the development of the case law around these two entities. So corporations been around for a long, long time. They're creatures of the 1800s. The courts are very familiar with them. There is a lot of case law on what should happen inside of a corporation. There is a lot less law, not nothing, but a lot less law with regard to LLCs, particularly because an LLC is so dependent on its operating agreement for the rules of the road, for what gives rise to liability between owners or between people who are working for the LLC and owners. So a classic example of this, somebody had a really great idea for a business. He was the driver of this idea. He put in, I believe, somewhere between $100,000 and maybe $300,000. But he said, you know what? I don't want to go it alone. I want to get somebody to bounce these ideas off of. He enlisted somebody with whom he did not have a particularly close relationship. And that person put in $30,000. Didn't lift a finger. The guy who had the idea and who drove the business really, really expanded very, very rapidly and did a ton of work, obviously put in the vast majority of the money. And then just a few months later, the guy who put in 30 grand and didn't lift a finger said, you know what? I want cash out of this business. I think you should stop amassing capital inside of this LLC. And I think that you should start paying out, out of the profits. But meanwhile, the smartest thing to do was to continue pouring, whatever cash they had on hand into growth because it was doing so well, it's picking up so much steam. And the LLC agreement was fairly clear that it gave the managing member the authority to keep reserves for the growth of the company, but there was no case directly on point in this jurisdiction. And the guy who only put in the 30 grand got a fairly aggressive attorney to argue this. Bottom line, that guy who put in 30 grand and didn't do much got paid 700 grand just to go away. And that's an extreme case. I don't like people making decisions based on extreme cases, but it does highlight the difference here. It's almost unthinkable that that would have happened in the context of a corporation because the case law is so well developed. Things are so clear that you can amass capital for growth. That is one difference, is the level of certainty you can have with the meaning of your legal actions in a corporation as opposed to in an LLC. Okay, next lens, ownership flexibility. So let's take an example. You have one guy with all the money, one guy who's putting all the work. So the guy with all the money puts in 500K, Sweat, we'll call him, puts in all the labor. In an LLC, the interest can be owned 50-50, but money, that partner or that LLC owner can get a different, kind of a customized return. He can get 55% of early gains on a 55-45 split, and then Sweat can catch up based on some agreed upon metrics of work or how much time he's putting into it. It's harder to get to that result with a corporation. A corporation kind of has this standardized form, and each share in a class of shares is entitled to a thing. So yeah, you can get to more customized ownership benefits, but it's a little bit more difficult. skipping, now we're on lens number 5. I'm sorry, just moving forward. Lens number 5, attractiveness to outside investment. So this is from different types of investors. Banks don't really care. If you're a corporation or you're an LLC, in some situations, they're going to look for a personal guarantee. Some situations they're not. I don't think there's a huge distinction from their point of view between these two entities. Friends and family, again, not necessarily a huge difference. Some of them may be attracted to the tax flexibility of LLCs, and we're going to talk about that again later, but even those benefits are somewhat limited. However, when it comes to established angels and venture capital, corporations are way, way more attractive to them. And that can be kind of a binary switch for your company. If your business is shooting for that VC money, we're going to talk about why you will want to be a corporation. So friends and family LLCs may offer some needed flexibility and tax advantages, but it's important to understand tax advantages for non-active participants of the business are very limited. There's a variety of tax provisions which are specifically directed at not allowing passive owners of LLCs to take losses on their individual returns just from owning a piece of a company where they don't do very much at all. Some people have the perception that, oh yeah, we'll just allocate all the tax benefits to me. It doesn't really work that way. Established angels and venture capitals. Okay, so many just will not look at LLCs. There are legal restrictions on some investors in venture capital funds, like retirement plans, where they are just not really allowed to own interest in LLCs. In addition, LLCs may be taxed with pass-through taxation. And a lot of those investors at the venture capital level just don't have an appetite for having tax effects until they cash out essentially at the business. It's just not something they're interested in at all. Excuse me. There's another advantage, which is corporations have these really, really, again, thoroughly understood generic classes of equity, whether that's something called a SAFE, all the way through getting traded publicly on an exchange. Everybody understands what those share classes are. Everybody understands the different kinds of investments you can make in a venture and pre-venture corporation. So it's really, really easy to talk about getting money from angels and VCs. It's really easy for everybody to understand what the deals are going to be when you're a corporation. There's actually something really cool, which is there's this rich ecosystem of securities forms, like you're going out and you're trying to get investment in your corporation. If you're a corporation, particularly a Delaware corporation, there's a lot of basically very, very well understood forms where you can reduce your legal costs because you can use these forms as your agreements between your company and your investors in a lot of cases. And everybody knows what they say, everybody knows what they mean, everybody knows which terms are variable depending on the deal. So it makes life a lot smoother if you are a corporation, and again, particularly a Delaware corporation. And for all of those reasons, operating as a corporation, if you are trying to get that VC money, shows that you get it. If you start as an LLC and then you have to convert to a corporation, everybody knows that you kind of didn't do your research. So generally speaking, starting out as a corporation, even though everybody kind of assumes, oh, there's disadvantages to being a corporation. When you start out as a corporation, it shows this class of investors, the established angels, the venture capitalists, that you get it. A word about Delaware corporations. Okay, so there are reasons we're talking about Delaware. It's slightly, the bad news is slightly more expensive to form an entity in Delaware. Number one, it's just a little bit more expensive. It's not necessarily a ton more expensive. You're going to think it is, but there's calculations with regard to, I think, the Delaware franchise tax where you can bring it down. And you also have to file two things. So now you have to file a Florida foreign corporation registration because you're going to be doing business down here, presumably. And you also have to file your entity formation and maintenance documents up in Delaware. Why are we talking about Delaware? Okay, Delaware has the highest level of legal certainty with regard to corporate law. They have this thing called a chancery court that's specific for business issues. and it handles lots and lots of corporate law and has done so for a very long time. Bad news is Delaware lawyers know this, so they charge, or they can charge, a little bit more to manage a lawsuit in Delaware. And if that's your home state, that may be where you're suing or being sued. Again, though, because Delaware is kind of the standard for publicly held corporations or very, very, very large corporations, you have that signaling value. You're telling those VCs, you're telling those angel investors, yeah, we got it from day one. We know you want to look at Delaware corporations. And again, you have the advantage of that rich ecosystem of corporate documents with regard to investment. And actually in other areas too, where they're a lot simpler for Delaware corporations than they might be in other jurisdictions, including Florida. Okay, so lens number 6, whether you decide to be an LLC or a corporation actually affects how you pay your employees. So if you want to pay your employees with stock, you are talking about a corporation, okay? LLCs don't have stock. And stock is a great word. Employees, like high performing employees, they know probably what stock compensation is. They have at least a vague idea that it's something exciting and gives them some ownership interest in the business that's kind of like theirs. They know and get it. It can be much more motivational than what you can give in an LLC. There are also huge tax benefits for stock compensation, generally, and they're generally only available inside of a corporation. In contrast, giving away equity in your LLC to employees is a bit of a nightmare, okay? Because it is much more complicated from a tax perspective, usually. You have these weird arrangements like LLC equity tracking units, okay? If you try to say LLC equity tracking unit to an employee that you want to get today, because that guy or gal is a high flyer and you want to attract them, you want to make them excited about working for you, it just does not have the same cachet as stock, okay? It's also generally more expensive to administer and deal with, and it's much more complicated from that employee's perspective on a tax basis as well. Stock is more attractive for employee compensation, and stock means corporation, not LLC. Okay, now we're in kind of like the third major section of this talk. We are talking about taxes, okay? We're in a post-Trump, pre-Biden world, okay? Expect incremental changes at the very least with a democratically controlled government. The Trump administration made a lot of changes in tax law without commenting on those changes. They're not things that we necessarily expect to stick around for very long, but it's hard to change tax laws sometimes. So we expect at least incremental change. We don't really know. But major change is more possible than usual because you've got Democratic control of both the White House and the Senate in this case. So it's possible. We really don't know what's going to happen. Two examples of this that are particularly relevant to our discussion of tax right now. There's some very business-friendly bits of the tax code that have been enacted under the Trump administration. There's something called Section 199A. I am not getting into the details of that today, but the bottom line is that for businesses that are outside of corporations, you can take a major chunk of your income from that business out of your taxes. Similarly, if you are taxed as a corporation, as a C corporation, we're going to talk about what that means. Tax rates are very low at the C corporate level. On a historical basis, they're much lower than they usually are. Okay, so remember in the beginning, we said we're going to talk about two decisions. We're going to talk about what state entity you are going to be, whether that's a corporation or an LLC. And eventually being right now, we're going to talk about how you are going to be taxed on that entity's profit and loss at the federal income tax level. Okay, so we got this grid up and we'll start at the bottom. So if you do not file a business entity, you're just doing business as yourself, you are a single owner, you are a sole proprietorship, you are going to be taxed as a sole proprietor, meaning it just shows up on your personal income tax return, okay? So there's no other entity out there. All of the income loss and all the items from that business that are relevant for tax purposes show up on your return. Similarly, if you have no entity, but you have many owners, you are a partnership in the eyes of the state of Florida. You are also a partnership in the eyes of the IRS, okay? Partnership taxation, we'll get into it, very complicated area, but you are a partnership. You will be taxed as a partnership. And again, you'll see that I wrote only choice and only choice there. Now, when we get to business entities, you have the ability to elect how you are going to be taxed at the entity level, okay? So let's talk about a single member LLC. So you have one owner of this LLC. The default taxation of that LLC at the federal income tax level is what's called a disregarded entity. So it's going to be as if there were no entity there whatsoever. Everything shows up on your personal return. However, you can elect for a single member LLC to be taxed as an S Corp. Okay, remember S Corp? We're going to talk about what that means. You can also you can also elect for it to be taxed as a C Corp. That's kind of grayed out. It's a much rarer situation, not useful for most businesses. Similarly, if you're a multi-member LLC owned by 2 or more people, your default taxation at the federal income tax level is your taxed as a partnership, okay? However, you can elect to be taxed as an S Corp. And again, we're going to talk about what these things mean later. And you can also elect to be taxed as a corporation. For the most part, disregard that. Now, let's say you're a corporation. Your default taxation at the federal income tax level is as a C Corp. So we've got C Corp, S Corp, partnership, and then just individual or disregarded entity. But you can elect to be taxed as an S Corp. Okay, so we've got C Corp, S Corp, partnership, sole proprietor, disregarded entity. Let's talk about what these tax classifications are. But first, we're going to make fun of people. So if you're talking to a lawyer and you're wondering whether to take business law advice on this person, from this person, or you're just like really bored, just ask this person, hey, how is an LLC taxed? Okay. If that person like proceeds to just go, well, an LLC is taxed this way, don't take advice from that person unless they're talking about the fact that an LLC, let's go back a slide, can be taxed in about 4 different ways, right? So if it's a single member LLC, it can be disregarded. It can be an S Corp. It can be a C Corp. If it's a multi-member LLC, it can be a C Corp, S Corp, or partnership. Okay, there's literally 4 different regimes that could apply for federal income tax purposes to an LLC. So the answer to how is an LLC taxed is, if you're asking me, I'm basically walking away. I don't want to deal with it unless I'm billing you by the hour, which, by the way, I really do try to avoid. Or it's a very long answer that begins with, well, it depends. Okay, this is one of those situations. So if somebody confidently answers that an LLC is taxed as a partnership or an LLC is taxed as an S corporation, no, it's just not. It's entirely dependent on the fact, who owns it, what elections are in place. It is not a straight up answer, okay? So if somebody starts telling you that confidently, run. Let's take a second. What taxes are we talking about here? We're gonna talk about 2 taxes, okay? As business owners, you need to be talking about these 2 taxes. We're gonna be talking about federal income tax, right? So that's the tax everybody's familiar with. That's your 1040. That's why you don't like the IRS. You've got individual rates somewhere between 10% of net income, 10% and 37%. We're also talking about a second tax. So this is employment and self-employment taxes. We're not going to get into the details of that, but they can add up to, there's different taxes within there. Some substitute for others in different situations. They add up to about 15% of employment or self-employment income. Okay, so let's talk about how you can be taxed. So let's say you're a single owner, there's no taxed recognized entity, which means either you didn't form a business entity at the state level or you're a disregarded entity. Okay, so for instance, you are a single member LLC. This applies to sole proprietorship, a disregarded entity. You're just taxed individually. Everything shows up on your return. You pay taxes on the gain and loss of the business. Pretty straightforward. Now, let's say you're taxed as a partnership. I am omitting the vast complications of partnership tax. Okay, it's a very, very tricky and awesome in some ways area that nobody wants to hear about. But the basics are this. If you are taxed as a partnership, who can be taxed as a partnership? That's a multi-owner unincorporated business. So again, you've just got what's called a partnership for state law purposes, or a multi-member LLC. By default, that is taxed at the federal level as a partnership. So with a partnership, there's no entity level income tax imposed, okay? There's basically the income, the tax significant items of the business, income, loss, deduction, depreciation, these things, they flow through the business and show up on the individual owner's returns. Okay, that is a vast oversimplification of partnership taxation, but the bottom line is it's what's called flow-through taxation. There's no tax imposed at the entity level, and items generally flow through to the owners, to the partners. In partnership, you have this flexibility. Okay, you can do what's called special allocations of tax items, which do allow for some shifting of tax burdens. But those special allocations must have what's called substantial economic effect. They can't just be completely made up. There are very specific rules about how they have to come back and bite you in the ass one way or another. Okay, option number 3, you can be taxed as an S Corp, okay? So what is an S Corp? First of all, who can be taxed as an S Corp, or what can be taxed as an S Corp? An LLC can be taxed as an S Corp. A corporation can also be taxed as an S Corp. You just have to file an election to be taxed as an S Corp with the IRS. It's a one-page form, very simple. Being taxed as an S Corp, it's called S for simple, basically. S Corps are pretty straightforward. So like partnership, so owners are taxed directly on entity level income, regardless of whether distributions are made. So I really actually should back up. Really important to know this, for both partnerships and S Corps, you are on the hook for being taxed for whatever income occurs inside that business, potentially even if you didn't individually actually receive the money. So it's really, really critical if you have a partnership or an S Corp to make those distributions to owners, so at the very least they can pay whatever tax might be due on business income, okay? So like a partnership, S Corp owners are taxed directly on entity level income, regardless of whether distributions are made. But S Corps, unlike partnerships, don't have so much flexibility. They have simplicity. There are restrictions on how complex your ownership structure of an S Corp can be to qualify to be taxed as an S Corp. So basically, at a maximum, you can have 100 shareholders. That's it. Married couples count as 1, not 2. You can't have what the tax code refers to as non-resident alien investors. You also can't have corporate or entity shareholders. So we're looking at something that's kind of close to the ground. It's owned by a few individuals, relatively few. And you can only have one class of stock, okay? Little asterisk here, non-voting common is okay. So you can have voting and non-voting common, but if you're interested in issuing preferred stock, S Corp is not your friend. You will not qualify to be taxed as an S Corp if you do that. So now let's compare these two things. We've got these two pass-through entities, flow-through entities, S Corp, partnership. So both of them don't have any entity level tax. S Corp has employment tax advantages. Okay, remember, we said we're talking about two taxes. There's income tax, there's employment tax. So S Corp distributions of profit are not necessarily subject to employment taxes. S Corp distributions to owners who are working for the company, if those distributions, and distributions we're talking about money, if they represent reasonable wages, those distributions are subject to employment taxes. However, if the S Corp distribution is a distribution of profits beyond those reasonable wages, then they are not subject to employment taxes as a general rule. Another difference between the two, single member LLCs cannot be partnerships. Okay. Now, maybe you can find a friend to own some fairly minuscule percentage of your LLC. Now you're a multi-member LLC. Now you can be a partnership, but a single member LLCs can only be S Corps. Multi-member LLCs can be both. Single member corporations can be S Corps. Okay. And again, this is a really, really interesting area from a tax law standpoint, but S corporations are generally not optimal vehicles for ownership of real estate. Their partnership is preferable for reasons I absolutely am not getting into today. Now you've got your fourth option of how to be taxed at the federal income tax level. Okay. Your corporation, your C corporation, your classic corporation, what the basic features of corporate taxation are this. You've got double taxation. What does that mean? It means income and loss are determined at the entity level, at the C Corp level. If there's income, the C Corp is taxed on that income, okay? Now, there's no immediate tax consequences to owners of shares in a corporation, to stockholders, shareholders, for corporate gain or loss. But when you dividend out that money to those shareholders, you distribute that money as dividends to those shareholders, or if they sell their stock, now they are taxed individually. So you've got those two layers of tax. You've got tax on income inside the corporation, and then you have tax on either dividends or gains on the sale of your shares in that corporation. Double tax sounds bad. It's not currently as bad as it sounds at first, okay? Number one, the corporation gets to take a tax deduction for reasonable wages. And in your startup situation, in even the situation of a lot of fairly profitable businesses, the vast majority of what could be the profits going to owners are actually coming out as wages. Again, you've got employment taxes on those, but it does reduce the federal income tax liability at the corporate level. It does reduce the amount that is actually subject to double taxation. You also have something, again, I think this is something that lawyers make a bigger deal out of than is real, but you have hassle-free retention of earnings. So let's say you want to accumulate capital for growth at the entity level. Technically, in an LLC and an S Corp, there are restrictions on that. Now, if you've got a valid business purpose for doing that, those restrictions generally don't matter nearly as much. But with a C Corp, retaining earnings is not a problem at all. The current C Corp maximum tax rates for federal income tax purposes are actually pretty historically low. The max rate is at 21%. Usually those max rates roughly track the maximum rates on individual income tax. So right now is a weird situation. Again, this is kind of a Trump administration creation. You've got individual tax rates as high as 37%, but corporate tax rates are down at 21%. You also have qualified dividends, which are certain dividends paid to shareholders of corporations. They're taxed at reduced individual rates also. So those can be as low, they can actually be lower than, but very frequently qualified dividends are taxed at 15%. Again, you're not getting the full brunt of double taxation, which historically might be 30-something% at the corporate level, and then another 30% at the individual level, although the individual level is always subject to some exceptions, or very frequently is subject to some exceptions historically. Right now, you've got really, really low rates of double taxation. You still got double taxation though. So the question is, why would anyone ever do this, right? One answer is there is some tax gamesmanship to be played. So if you have income that you're a very high earner in an individual level, you'd be taxed at 37% for sure. You can stick that inside a corporation, only get taxed at 21%, maybe hold on to that money for a while, invest it in something. The time value of money may make that worth it. That's in certain situations. One reason you stick with a C corporation is, again, because it allows you that access to capital markets, to venture capital, to established angel investors. You also have some very, very specific tax benefits that are very, very important to some people, okay? You've got this idea of founder stock under section 1202 of the Internal Revenue Code, and that is huge, huge for some people, okay? You can exclude gain from the sale of stock that's been held by more than 5 years in certain common founder situations. So you're the founder of the company, you hold on to the stock for a very long time, it becomes extremely valuable. You can walk away without being taxed on around $10 million of that founder stock, sometimes even more in certain situations. So that can be a really, really critical part of your decision to be taxed one way or another. Another situation is employee compensation. Many of you might have heard of Section 83B elections. It's a way to potentially save some taxes on stock-based compensation of employees. It really only is relevant for the most part to stock and C corporations. And again, employee compensation with stock is just overall much less complicated in the corporate and in the C corporate situation. Oh, bear with me. Okay, so we're just about done. I do want to just give 2 examples of how this all works out practically, where the answer is sometimes a little bit clearer, because I know I've thrown a lot of information at you and it's hard to understand how important is this lens, how important is that lens. So one example that we see pretty commonly is your tech startup, okay? They're marked by, they need access to that outside capital tied to equity, that VC money, that angel money. They do want to reward key employees with equity, stock, or with options. And frankly, they expect losses or reinvestment of profits early on. They're growing, they're going 0 to 1. They're trying to take over the world with their idea. Here, what do you want to do? I'm sure you know the answer already from what I've said. You form a Delaware corporation, you register to do business in Florida if you are from Florida, and you get taxed as a C corporation. Why? Again, angel and VC friendly structure. They're more ready to give you that money. You have this rich ecosystem of cheapish offering documents. So again, when you're offering investments in your company to these more sophisticated investors, yeah, you might be paying a little bit more for your Delaware registration. You might be paying a lot more on taxes, not necessarily the case, but you might save a ton on legal fees with this rich ecosystem of cheap-ish documents. Again, you've got that good signaling. These people know that you have done your homework ahead of time. You've got limited negative tax consequences. So basically, there are some disadvantages of operating as a corporation as an owner. Losses don't necessarily pass through to you, but some of the gains don't necessarily, well, let's not talk about that. We'll talk about that later, but limited negative tax consequences, particularly if you're not making that much money at the corporate level, you're growing. You also have positive tax consequences for founders and stock compensated workers, as we just discussed, that 83B election for stock compensated workers and that section 1202 for founders. On the other kind of side of the spectrum, let's say you have a single owner, profitable lifestyle business. So you're my buddy Joel out there. You are a creator, you are a videographer, you are selling a service, and you're doing well at it. And it's just you. You don't have any real estate, you generate reliable profits beyond the market value of your labor, meaning if you were to go just work for some other company, you just wouldn't make this much money. You're doing really well. You don't anticipate needing equity investments from third parties. And again, you have no real estate. So your choice here might be form a Florida LLC and elect to be taxed as an S corporation. Why? Well, LLCs are pretty low hassle, not quite as much paperwork as a corporation. There's no entity level income tax, unlike with a C corporation where you would incur that kind of double taxation or that cascading tax. And now you can do that thing we talked about, which is reduce your employment taxes. So you're going to pay employment taxes on your wages from the LLC, but you're going to make S Corp distributions of profits to yourself that will be subject to income tax, but won't necessarily be subject to employment taxes. And that can save you a lot of money. Okay. So those are two cases where all this information that I've kind of thrown at you kind of comes together in some more predictable answers. And that's it. That's a really, really broad overview of the law that's relevant to your decision to choose to do business under a business entity and which one you might want to choose. I absolutely encourage you to do a little bit of research to discuss the needs of your particular situation with a qualified business attorney. And for some reason, my contact information is up there. You can go to www.maxlevinlaw.com. And I'm going to be putting up more informational videos for business people who want to integrate a knowledge of the law into their business decisions proactively to avoid turning issues into problems. That's what we do. So if you want to talk to us, by all means, reach out. We're excited to help any business we can help, and just happy to be in front of you right now. Thank you for watching this.